everybody, and welcome to Law and Crime. I'm Jesse Weber, and thanks for joining us here on the network, where we cover the most interesting live trials and legal stories in the news today. Let's get started right now. The trial for the mother will begin today. Let's get some perspective right now from criminal defense attorney Roger Foley. Roger, thanks for joining us here on Law and Crime.
Thank you. Good morning to you.
You know, I look at this case, still haunts me, still think about it, and now we're going to be covering the trial of the mother. Have you ever seen anything like this before?
I haven't. It's so tragic as I listen to those opening arguments and you just hear those words and you think about the suffering that that child was put through. It's a travesty. It's sad. It's tragic. And it's overwhelming. That opening argument gave me chills.
Yeah, and look, I'm not I can't read people, but based upon what the judge appeared to be listening to the prosecution's opening statement, he appeared to be startled by what he was listening to. And the question is, what would the defense argue in this case? Well, let's see what they said in their opening statement.
Not a crime is what we expect the evidence will show. My name is Les Blair, and along with my colleague, Stephen Drahosel, we represent Zachary Key, the defendant in this matter. I'm going to keep this short. As you already heard, this case is about the death of a child. Nothing anybody says throughout this trial is going to soften that. It's a terrible thing. The problem is, of course, that a tragedy like this creates a gut reaction in us. We want to punish somebody. There's an automatic tendency to what we refer to as rush to judgment. As jurors, it is your responsibility, it is your job not to do that. Now, I'm not going to talk about each individual witness and what each individual witness is going to say. I simply want to point out to you that the state gets to go first. They present their entire case. The defense doesn't get to present our evidence until after the state is done. Because of that, you need to make sure that you keep an open mind, that you listen to all the evidence, and that you don't draw any conclusions or reach any conclusions until after you've heard everything. Because there's going to be a lot here.
Roger, the interesting thing about the defense in this case is they seem to have put the blame on the mother. And that didn't work out so well. He was convicted, but now we knew this trial was coming up of the mother. Don't we expect a different kind of defense from Cheyanne Harris's legal team?
Absolutely, Jesse. With the blaming the other person, crossing, paths and saying, oh, it was the other person that had the responsibility. That's not going to work. So Ms. Harris is talking about an intoxication defense, talking about, I'm assuming, her drug usage and the problems she's had with drugs and the diminished capacity she may have had. And for the listeners, it's basically that she was under the influence of drugs and could not be responsible to the level of a first-degree murder. Doesn't mean that she's not culpable and she's not negligent, but what the defense, at least what we're guessing at this point, is going to make an argument for a lower-level charge, not first-degree murder.
Now, I know you had said you never really saw a case quite like this before, and thankfully you never have, but the idea here that if she was on drugs, meth, which is what we believe, have you ever seen it successfully work in a child endangerment, a child neglect case quite like this?
I haven't, and we don't use that defense here in Florida. However, I did some research, and I was struggling to find successful defenses of this. I heard many experts or so-called experts saying, hey, this is a defense that should be used. But I didn't see any cases in Iowa that jumped out at me because I think the standard, Jesse, is, and I wrote this down, is the intoxication defense can only be used when it causes a mental disability which makes the person incapable of forming the specific intent. And that's a burden that the defense takes on themselves.
How does that work exactly, though? So her capacity would be so affected that she didn't know what was going on? I mean, what does that really mean?
Correct. She would have to be to the level of impairment, and that's not what I've heard in the facts so far, but we're going to find out during this trial, that her ability to care for the child was diminished so much that she really didn't even know that she was there. And the case law that I read says that even if there's a scintilla of evidence that she had her mind about her, then the defense doesn't work. So it's a very difficult defense.
Yeah, and we're going to have to see how it works, and we have to see what they ultimately argue. We do expect opening statements in under an hour. We will let you know. We're going to take a quick break on our end, but when we come back, we're going to recap more of the Zachary Keene case. We'll be right back. Welcome back to Law and Crime, everybody. So we are waiting to be live in the Cheyanne Harris case. Day one, opening statements. She is charged with first-degree murder and child endangerment in connection with the death of her 4-month-old son, baby Sterling. Now, here's the interesting part. We covered the trial of the baby's father, Zachary Keene, and he was found guilty and sentenced to life in prison on the same charges. We're recapping that case to see what might happen in the future trial today. And right now, let's move on to the body cam footage of Officer Martin Heeman, who was actually the one that interviewed the defendant, Zachary Keene, and we can learn maybe what ultimately happened to this baby. Take a look.
When I got home, I crashed. It was like nighttime. Yeah, exactly. And she come in and woke me up and said he was gone. Okay. Cheyanne did? Yeah. So I got on the phone and called y'all right away. So I was a little disorientated and then woke up and told my son's dead. Okay. Still hard to believe. Does Cheyanne work at all then? Okay. She stayed at home. So she stayed at home with the kids then? You were sleeping this morning? Yeah. Okay. Sterling, was it a normal delivery and everything, or was there any complications? I delivered him. Oh, you delivered him? And the rice filled and let the ambulance come. Okay. And they took him to the hospital, and they monitored him for a day and they sent him home and said he was fine. Okay. So did Cheyanne just go into labor like really quick or things? Or? Yeah. Okay. Well, he was early. Okay. So she thought it was intoxication actually at first, and then he was coming. There was nothing we could do, so I put her in the tub with the warm water and delivered it.
Okay, Roger, now we luckily have never seen cases quite like this, but you've seen neglect cases before, and some of the ways that what he's describing, being the one who's not responsible, is that something you've seen before?
Not really. Usually it's a lot of the cases that I've seen are one-parent cases where it's a single parent, a young mother, that sort of neglect. This doesn't just tug at your strings. I mean, this pulls your heart out to know that this baby suffered like this. I mean, only 4 months old, a full life to live, and his defense was essentially, hey, the mom was responsible. She's the one that takes care of him. I was sleeping. I work. Not the best defense, but what do you say in this sort of circumstance? Obviously, the parents have responsibility to care for their child, and if they need help, there's an abundance of services available. So clearly an uphill battle for the defense in that case.
Yeah, or the answer is don't become a father. Maybe you shouldn't have had a child, and maybe that's really the answer. But let's keep going, and let's play the testimony of Jordan Clark, who is the co-defendant's, the co-worker and friend, you could say, of Zachary Keene, provided very illuminating testimony about Zachary Keene's relationship with Sterling. Take a look.
During all those times that you saw the defendant, did he ever tell you that he had a baby?
Not that I can recall.
He didn't tell you that he had a baby son?
No.
Did you know he had a little girl?
Yes.
Did he talk about the little girl?
Yes.
How often would he talk about his little girl?
At least once a night or every time I see him.
But never about the baby? That no?
No.
What would you do with the defendant when you were at these breaks?
Usually just talk or kill time just sitting around.
Did you ever use drugs?
Yes.
Did you use drugs yourself?
Yes.
What drugs did you use?
Myself, meth.
Did you ever see the defendant use drugs?
Yes.
What drugs did he use that you saw him use?
Meth and cocaine were the main two. A couple of rare occasions was marijuana.
How often would he use the methamphetamine?
Daily.
Did you ever go to his apartment?
Yes.
How many times did you go to his apartment?
Like 2 or 3 times, I believe.
And where was the apartment located?
In Alta Vista.
Can you describe where you went inside the apartment?
Right in the main door would be the living room, and then into his bedroom on the left side.
So when you walk into the apartment, there's 2 bedrooms, is there not?
I believe so, yes.
And did you go into one of the bedrooms?
Yes.
And what was in the bedroom you went in?
It was just a TV, mattress, some clothes, I believe.
And was that Zach's bedroom?
Yes.
The defendant?
Yes.
Did you ever go in the other bedroom?
No.
Did you ever see the other bedroom door open?
Not that I can recall.
And how many times were you at that apartment?
2, maybe 3 times.
What did you do at the apartment?
Mainly just sat around, kind of BS back and forth.
Did you use any drugs at the apartment?
Yes.
Who used drugs at the apartment?
Me and Zach.
How about Miss Harris? Was she present?
Yes.
Did she use any drugs?
Yes.
What drugs did you use at the apartment?
Meth.
How did you ingest the meth?
I smoke.
How about Mr. King, the defendant? What drugs did you see him use at the apartment?
Just meth. Just meth.
How did he ingest it?
Smoke as well.
How about Miss Harris? What drugs did you see her use at the apartment?
Just meth.
How did she ingest it?
Smoke.
Where was Mallory, the 2-year-old?
She would be out in the living room.
Was she present when the drugs were being ingested?
As in the same room?
Yes.
No.
Where did you use the drugs at in the apartment then?
I was in his bedroom.
Roger, I'm not sure I understand this, okay? He has a baby son and doesn't tell this guy, but tells him he has a daughter.
It's unbelievable. Anger, and I can't imagine the jury. That's why he came back and, guilty in such a short period of time. These 2 people are paying more attention to their drugs and their friends than they are their own children. It's disgusting.
Well, we did get some more answers from Sheila Schroeder, who's from the child protective worker at the Iowa Department of Health and Human Services. So she took the stand and talked about her communications with Zachary Keene after Sterling died. Take a look.
Can you ask the question again?
Yes. Would it make sense to you that someone would be uncomfortable talking about the death of their child?
Yes.
Does it also make sense to you that someone would be nervous talking about that?
Yes.
Especially somebody who works for the state?
Can you repeat the question?
Especially somebody who works for the state.
Can you ask the question a different way?
Would it make sense to you, especially that someone would be nervous talking about the death of their child to someone who works for the state of Iowa?
Yes.
Did you identify yourself as an investigator when you met Mr. Kane?
Yes, I did.
Do you know Mr. Kane's education background?
No, I do not.
Do you know whether Mr. Kane was aware of the difference between DHS Department of Criminal Investigation or law enforcement otherwise?
Based on his comments, yes.
When Mr. King told you that he used methamphetamine, he told you that he used it to stay away from work, correct?
That is correct.
And he also told you that Cheyanne had found Sterling dead, correct?
Yes, he did.
And I believe you said that he told you that he thought it was SIDS.
That's correct.
Mr. King told you that he did not change diapers for any of his children, correct?
Yes, he made that statement.
And you talked about Mr. King's attitude with you being dismissive, and he told you to go ask law enforcement. Were you aware that at this point Mr. King had been interviewed by law enforcement?
Yes.
Can you imagine how trying it would be to discuss the death of your infant repeatedly, people asking the same questions?
Yes.
Okay, so Roger, one of the interesting things to note there is that Zachary Keene had initially told, people that were asking about what happened, I think this might have been SIDS, sudden infant death syndrome, when he had no evidence to back that up. And I wonder if the jury heard that and said, well, that's really suspicious. He came with that answer so automatically. And I don't know if Cheyanne Harris said the same thing. I mean, we're expecting her trial in about a half hour or so, but I'm curious what you thought of that part.
I think that he just probably heard the term. I mean, he also told the investigator and police that he doesn't change diapers, and he hasn't done it for any of his kids. If you have a wife that has an addiction and you think that she may not be taking care of the kid, you got to step up. Nothing that this gentleman said to police or to investigators helped his case, and it just showed neglect, and that neglect caused the death of the child.
Looking at this witness, you can't also help but think people want blame. They want to put the blame on somebody. I guess the question is, how come an agency didn't step in to try to prevent the death of this baby? I mean, how did this happen?
They always say it takes a village to raise children, right? So the mothers testified at some point that she took care of the child, that the child had a little rash. She helped with that rash. The rash seemed to be getting better. But that was occasionally, possibly a day on a weekend, not a constant thing. It's surprising, right? I mean, I guess there were neighbors that talked that they didn't even know that they had a little girl. It's just sad. It's a horrible situation.
It's sad all around, and trying to make sense of it. I don't know if we can even do that, but I'll tell you what, we are going to be live in that courtroom today. Brand new trial of the mother, and hopefully we'll be live in under a half hour. So let's take a quick break. When we come back, we're going to play you Zachary Keene's 911 phone call. We'll be right back. Back to Law&Crime, everybody. We're waiting for the live feed in the Cheyanne Harris case out of Iowa. Day one, opening statements, we believe, might begin in under a half hour. So as soon as we have the feed, we're going to make sure to go there. But right now, we're previewing that case by going back and analyzing its companion case, the Zachary Keene trial. This is all about the death of 4-month-old baby Sterling. And we saw that Zachary Keene, the father, was found guilty of first-degree murder and child endangerment. And now we are going to begin the trial of the mother. Where we last left off, we were trying to understand what ultimately happened when this baby was found dead. And that moves us into Zachary Keene's 911 phone call. If you haven't heard it, take a look.
See our son in about 11:30, to check on him, and he was gone.
Gone meaning?
He died.
Okay.
He had probably 4 months. I don't know if it was sudden death syndrome or what.
Okay. So you live at 107 South Hilltop and 8 in Alta Vista?
Apartment 7.
Apartment 7? Okay, and your son's 4 months old, and the last time that you checked on was 9?
No, she was trying at 9.
Okay.
And heard him cry or whatever. So probably about 11:30, 11:40, he went to check on him. He passed away.
Okay, so that's the last time they checked him. Okay, what's your phone number there, Zach?
406-223-2190. Pretty good last time I checked. I didn't see it me out. I'm sorry.
Okay, I'll get them paged out, okay? I'm going to send an ambulance and everybody up there, okay?
Okay, thanks.
All right, thanks.
Okay, we're analyzing the first reactions from Zachary Keene, and we're going to probably analyze the reactions of Cheyanne Harris in her upcoming trial today. Roger, I want to ask you, speaking about her trial today, we believe that the jury is composed of 10 men and 4 women. What does that tell you?
I'm not sure what it tells me. It tells me that anybody, man or woman, is going to listen to these facts, and they're going to be heartbroken. And just like the defense attorney said in the first case, they're going to be looking to blame somebody. Whether the defense works or not is still, remains to be seen. But this is a difficult case. I guess that the argument is that, men tend not to rear the babies, but that's not so in 2018. We have stay-at-home dads, we have stay-at-home moms. It's changed a lot from the 60s and 70s. So I think that those men are going to feel just as much grief as any woman, knowing that a child died sitting in a swing, not being cleaned for a week, possibly not being fed, malnourished, and sitting in its own urine and feces. It's disgusting and it's overwhelming, and I'm curious to see how this defense goes and how this trial plays out.
It's horrifying. It was horrifying probably to sit on the jury in the Zachary Keene case, and it's probably horrifying to be sitting in the Cheyanne Harris case. Again, we do expect a live feed any moment. We'll let you know. But right now we're talking about what we know about this case based upon testimony in the Zachary Keene trial. And let's continue on with Tony Friedrichs, who is a registered nurse and a first responder. Difficult testimony. Take a look.
A man and a woman and a child, and got out of my car and went running towards them and said, "Where's the baby?" They didn't show any emotion or expression. And then the man said, "Inside." And I said, "Show me." And so he took me inside, and we walked through the living room, and then he took me to a back bedroom, and it was dark and hot. It was stuffy. And I was looking for a crib, and I couldn't see anything. And I said, "We've got to get some lights on in here," because you couldn't see anything because it was dark. There was it was dark. And so he flipped on the switch and the lights came on, and then as he was walking away, he muttered something which I didn't hear. And then I turned and I'm getting...
That's okay. So he flipped the lights on for you?
Was standing. You still really couldn't see the baby because the swing was in the corner of the room facing the outside wall. And so I went over to the baby, and then because you had to get over in front of it in order to see him, and so then he was staring. He had his eyes were open, and he was a blank stare. His pupils were fixed and dilated.
What does that mean to you?
That means he was just staring, and the pupils, there was like no reaction in them. He was just staring. Sorry, I don't mean to. His eyes were fixed and dilated, and pupils should kind of sometimes move, and his didn't. And he never blinked, he never, and so then you go ahead and you do, you know, your assessment on the child. I went down to look, listen, and feel, breathing life, basic life support. He wasn't breathing, checked his brachial pulse. His arm was cold and stiff, and he had what appeared to be blood around on the side of his mouth.
So at this point,
and what a horrifying discovery that was. Roger, we're waiting for the opening statements in the Cheyanne Harris case, where we're going to hear these details all over again. But from both sides, in your perspective, what do they need to do in an opening statement, given how emotional and how disturbing these details are?
For the prosecution, I think they're going to do it the same way that it was done in the Keenan case. They have to, the prosecution is just going to tell the story. It's going to list out the witnesses and what the evidence is going to show. And you just heard from that nurse, there was no rush. There was no hurry up and get in here and save my child. It was a foregone conclusion. And the child is sitting in a swing facing a wall. And the nurse describes how she has to get in front, you know, put herself between the wall and the swing. I mean, that is emotional testimony. And as a prosecutor, they're gonna hit on that right in opening. For the defense, I think they're going to have to get right into the drug addiction if they want to try to mitigate or get a reduced charge in this case. They're going to have to really be talking about the intoxication, the effects, how often she was using, make her a little bit of the victim, but it's very difficult to do. People are empathetic to people who have drug addictions, but it's very difficult to be empathetic when there's a dead child.
That's a great point. And listen, we are waiting for the opening statement, so let's take a quick break. When we come back, hope maybe be live in that courtroom, or at the very least, we have a lot more to talk about. We'll be right back here on Law and Crime. Welcome back, everybody. We're waiting to be live in the Cheyanne Harris case. We expect opening statements at around 11 a.m. Eastern Standard Time, but maybe we'll get something before then, but I'm keeping a careful eye on the courtroom feed. In the meantime, as we wait to begin the beginning of that trial, let's go to the end of the Zachary Keene trial, a companion case to the one that we're about to cover. Again, we're talking about the death of 4-month-old baby Sterling. His father was found guilty of murder and child endangerment, and now the mother is about to face her trial on the same charges. Let's begin right now with the prosecution's closing argument from the Zachary Keene trial.
We know that they're intentional because he knew that Sterling wasn't being cared for. Right? He can say all he wants that he didn't know, but do you find that credible? Did you believe him when he told you that a day or two before Sterling was found on August 30th, that he was in that room and Sterling was holding his fingers and he was playing with him? That was not honest. He knew what was going on with Sterling, and he didn't care because he did nothing about it. He knew that Cheyanne was not doing her job. Now let's be clear about this. Define the roles in your household however you would like. That's perfectly fine. But keep in mind that your job is no problem. But if your spouse stops and your child becomes ill, becomes hungry, needs change, and there's no one else to do that, then it's still your job as the parent to step up and to keep your child safe and to keep your child healthy. So this excuse of it wasn't my job doesn't fly in this situation. It was his job to be a parent and to care for his child, no matter what. What you know is that within a 26-day period, Sterling went from thin, what we know is probably being underfed from Dr. Klein's testimony. That malnourishment had been going on for longer than just the last few weeks of August, but it wasn't to the extreme until the end of August. So maybe he wasn't getting enough up until that time, which is why he was so thin, but we know in August he was getting nothing from working in. So within that 26 report for August 30th, he went from thin to starving. You take one look at that last photo of Sterling taken on July 15th.
Okay, Roger, as we listen to the prosecution's closing argument, one of the things that struck me during the course of this case was the fact that the couple had another baby. They had a 2-year-old, I think a baby girl, and really the question is, couldn't they just say, jury, if you're the prosecution, they have another child, that child's okay. It's not like they didn't know what to do. This is so different. I mean, it's different than, you could argue, do tell me, is it different if they only had baby Sterling and no other children?
No, I understand that argument. Obviously, they have a 2-year-old, and that 2-year-old has survived, and they knew what to do. So there's definitely that argument for the prosecution to say, hey, they've done it once before. You can't say that they're not understanding, that they don't have the experience, the age. So that argument would fail from the defense perspective. But it's just tough. I don't know why that argument was made, that it was the other person, meaning that it was Cheyanne Harris, it was her responsibility. To say that as your sole defense, I just think that's a very difficult defense. Hey, I'm not responsible. It's just a weak argument, and obviously we see what the result was. He was convicted. Whether that conviction stands and stays as first-degree murder or not is another story, because I think it may end up being changed to a second-degree murder.
We're going to talk about what that means in a second, but let's go back to his defense that you mentioned it. In the defense's closing argument, let's see how they summarized why they believe their client should be found not guilty. Let's see.
I want to remind you that as the court has instructed you, Mr. Kane, there's no burden of proof in this case whatsoever. We don't have to prove anything. I believe the evidence in this case does show what happened. It's natural for us to say, how did this happen? Well, early on, we know that the parents were meeting Sterling's needs. They're sleeping, sitting up because of respiratory needs. They were feeding him, providing diaper ointment for a rash, changing wipes, meaning that when the sensitive skin had a problem, they changed the wipes to address that problem. Changing diapers, both changing dirty diapers, changing the type of diapers to address skin issues, providing organized.
Roger, let's just take a step back and talk about being a defense attorney in this case and also the Cheyanne Harris trial. Is this the most difficult job of any attorney?
Absolutely. So difficult for these defense attorneys to mount an argument. Obviously, they did the best that they could with what they had, but it's extremely difficult because not only are you defending your client, but you have to keep in consideration that child, and that is going to play on any defense attorneys, because no one wants to say, oh, it's okay, because it's not okay. You're really playing from a position of mitigating and trying to reduce the charges so your client has a less time of incarceration.
Now, we're waiting for the live feed in Cheyanne Harris. When the defense seemingly will put on their opening statement, they have to tread a careful line. So what are you looking out for today?
Well, I think if they're going to use this intoxication defense, basically what they're doing is they're admitting that she has culpability, right? They're admitting that the crime has been committed, but based on her intoxication defense, if the jury's to believe it, they're saying that it should be reduced to a lower charge, not a first-degree murder. That's all that intoxication defense is doing. It's not going to absolve her of guilt. You know, if they use that defense, she will be found guilty of something. It's just whether it's first-degree murder, second-degree murder, or possibly a manslaughter.
Right. There was no intention to kill him. And that brings us up to something you mentioned earlier. Zachary Keene's defense team is now asking for a new trial. Correct me if I'm wrong, because they say that there's just an error here, that there's no evidence pointing to the defendant intentionally starving, dehydrating, or otherwise causing the death of Sterling. Will that work? Will he get a new trial?
Jesse, I don't know if he's going to get a new trial, but I'm going to read to you briefly the jury instructions, what the jury heard. And the first thing that the jury was told was on or about this time period, 2 weeks, that the defendant failed to give care, right? So that's one element. If you agree, check yes.
Yeah.
That the victim was a child. But number 4 is that the defendant acted with malice aforethought. What does that mean, to the common person? That means premeditation, that they planned this. I don't think this was planned. I think this is pure neglect. And I do think that an appellate court may consider reversing, maybe not giving him a new trial, but reducing it down to the second-degree murder charge, which seems more fitting.
Well, to play devil's advocate, what evidence did they present that looks like, at the very least, that this was intentional? I mean, this is going to sound strange, but is there a thing as intentionally neglecting the baby? I mean, really, if he doesn't even tell his coworker and friend that he has a baby son, that gave an insight into this. The fact that he seemingly lied about what happened to the baby, saying, I think he was a victim of SIDS, sudden infant death syndrome, when really he had no evidence to back that up. Is that the prosecution, the state's strongest argument that this was intentional?
Correct. It's because of his lack of action. He didn't act. So what the court's going to ultimately look at is, can that premeditation be defined by his lack of effort, by his lack of care, by his lack of putting the responsibility on another person and not himself as one of the parents?
Now, we are talking about the beginning of the Cheyanne Harris case. It hasn't even started with opening statements yet. There's a lot to go through. The jurors in this trial found Zachary Keene guilty in less than an hour of deliberations. Do you believe that this will be a more difficult case to decide for Cheyanne Harris than it was Zachary Keene?
I do. Based on the defense, if they have to lay that foundation of her addiction, how long she was addicted. And then again, I think those key pieces are that Children and Family Child Protective Services weren't involved, right? So you have a mother who gives birth to a child who's struggling with an addiction. The hospital knows, the paperwork's forwarded, and I don't know. I mean, we're going to hear, is there any evidence that anyone got involved and tried to help, because you have a remedy for disaster?
Yeah, that's the best way to say it. It was a remedy for disaster, and this was just a ticking time bomb waiting to happen. Roger, I know our time together has come to an end, so we're not going to be able to watch this trial together, but I want you to watch it so you come back on and we can talk about it. Thanks so much for coming on. Of course. All right, so we are expecting to be live in that courtroom any minute. Let's take a quick break. When we come back, we might be live with opening statements in the Cheyanne Harris case out of Iowa. We'll be right back here on Law and Crime. Okay, Roger, as this witness described, the details are horrifying, really, really disturbing in a lot of different ways. But how do you tell the jury, listen, what you're about to hear is probably something you've never heard before, but how do you tell them to follow just the law? Because if there's any case where emotion might get in the way, it could be this one.
Absolutely. Talks about that, no testimony from the lawyers. Anything that they say is not testimony. To listen to the witnesses and to focus on the law, and that they'll explain the law. And part of the voir dire is asking jurors, hey, this is going to be a very sensitive case. Are you going to be able to follow the law? And getting an affirmative, getting a yes from each and every juror, because they're going to talk about this a little bit in voir dire when they choose that jury, right, so that jury members know what they're dealing with.
Yeah, it may be easier said than done, just being not allowing emotion to get in, but we're going to talk more about it. Roger, stand by. Let's take a quick break, and we're waiting to be live in that courtroom. Stay tuned. We'll be right back. And And, of course, you can go to Law&Crime.com to learn a little bit more of the top trending stories of the day or details in the El Chapo trial. Right now, we're going to switch gears and talk about our live feed in the Cheyanne Harris case. We expect to be live any moment. Now, if you're just joining us, you don't know any details about this, our very own Rachel Stockman has more. Take a look.
A young Iowa mother faces first-degree murder and child endangerment charges in connection with the death of her 4-month-old baby, Sterling Keene. Sterling was found dead and covered in maggots in his baby swing on August 30th, 2017. Authorities say the baby had not had a diaper change, bath, or been removed from the seat in over a week. The parents Zachary Keene and Cheyanne Harris are charged with baby Sterling's death. Authorities first responded to the home that morning after King called 911.
And she's come in, looked me up and said he was gone.
Okay. Cheyanne did?
Yeah. So I got on the phone and called y'all right away. So I was a little disorientated and then woke up and told my son's dead.
He claimed the baby was fed at 9 a.m. But when they checked on him just a few hours later, he had died. The medical examiner ultimately ruled the death as a homicide caused by failure to provide critical care after an autopsy found maggots in various stages of development on the infant. The baby also had an extreme diaper rash and caused E. coli to enter into his bloodstream. Zachary Keene testified at his trial in November, which we showed here on the Law&Crime Network. He said that Harris was the primary caretaker of the child. Keene was ultimately found guilty after about an hour of jury deliberations and sentenced to life in prison. He is now seeking a new trial. If convicted, Harris also faces life in prison, the mandatory sentence for first-degree murder in Iowa. I'm Rachel Stockman for Law&Crime Network.
Thanks, Rachel. And now we are expecting to be live in the Cheyanne Harris case out of Iowa any minute. But in the meantime, let's talk about what we can expect today. And joining me back here is criminal defense attorney Roger Foley. Roger, one of the things I want to talk about is the fact that the Cheyanne Harris defense team and the defense strategy will probably be different than Zachary Keene's. I was hoping you can elaborate on how viable is this defense that maybe she suffered from postpartum depression, maybe she suffered from PTSD, and perhaps the idea of a meth addiction falls into that involuntary intoxication defense. I'm curious your thoughts on these kinds of defenses.
I think it's very important that they lay the proper foundation, that they talk about her level of addiction when she started. And in doing so, I think that we're going to most likely hear from her. I think she's going to get on the stand, and I think the defense is going to have to talk about the addiction, the day-to-day, the struggles, what caused her to get there. They also need to talk about her age. She's only 20 years old. She's 20 years old with a 4-month-old baby. And then we have to get her talking about remorse. With the other trial, with Keene, there was not much remorse there. He sort of just blamed the other person. Because this is such an emotional case, right? Everyone wants to point a finger and charge. I think you have to get some emotion and talk about the life of this young lady if you want to give her a proper defense. Because the jury right now, when they hear that opening statement, as much as they're told, wait until the end and hear all the evidence, it's hard not to jump to a conclusion.
Oh, absolutely. And that's what I'm curious about with Cheyanne Harris. Is it realistic? Is it possible that she could be found not guilty and not found guilty of anything? Or, as you had said earlier in the program, she will be found guilty but of a lesser charge. I want to first start with, is it possible she could be found not guilty of anything?
I don't think so. Not with the facts that I've heard, that I've read, that we've discussed here on the show. Jesse, I think you never say never, right? That there's always hope, but there's not a high likelihood that that'll occur. I do believe that she will be convicted. Whether it's first-degree murder, I don't know if it meets the fourth element, that the defendant acted with malice aforethought, meaning premeditation. I think that likely it's a second degree or a manslaughter for the negligent care, the abuse of that child.
Well, it will be interesting if there's a different result in this case than the Zachary Keene case. You know, a father and a mother, two separate things, two separate scenarios. And speaking of the father, let's go back to the Zachary Keene trial when we covered it here on Law and Crime. And we saw the body cam footage of Officer Martin Heeman, who interviewed Zachary Keene after Sterling died. Take a look.
When I got home, I crashed. It was like nighttime.
Yeah, exactly.
And she come in and looked me up and said he was gone.
Okay. Cheyanne did?
Yeah. So I got on the phone and called y'all's right away. So I was a little disorientated and then woke up and told my son's dead.
Okay.
Still hard to believe.
Does Cheyanne work at all then? Okay.
She stayed home.
So she stayed at home with the kids then, you were sleeping then this morning?
Yeah.
Okay. Sterling, had he had any, was it a normal delivery and everything, or was there any complications?
I delivered him.
Oh, you delivered him?
When the Riceville and the ambulance come.
Okay.
And they took him to the hospital and they monitored him for a day and they sent him home until he was fine.
Okay. So did Cheyanne just go into labor like really quick or things? Or?
Yeah.
Okay.
Well, he was early.
Okay.
So she thought it was Constipation actually at first, and then he was coming. There was nothing we could do, so I put her in the tub with warm water and delivered him.
That's Zachary Keene holding his other child as he's describing the death of his other one. Now let's move on to Jeremy McGrath, who's a paramedic and a medical investigator, talking about what he saw when he came upon baby Sterling. Take a look.
Doorway to doorway, yes.
So did you go in to the baby's room?
Yes.
What did you do?
I was greeted by the first responder that was there. She kind of briefed me real quickly. Obviously, I've seen an infant in the swing, and she was standing there, and she briefed me on the circumstances that she had seen, and I did an assessment of my own.
And the first responder, that was Tony Friedrich, correct?
Correct.
Did you notice any smell when you were in the room?
Yes, there was an odor, one that I do not recognize. I've been on numerous calls where somebody had been deceased, and there's a certain odor, and this wasn't it. It's an odor that was difficult to describe.
What do you find in regards to rigor with the baby?
What I found was the rigor was present. As I lifted the baby's arm to assess it, or him, it was stiff.
And when you wrote your report, how did you, are there different levels of rigor?
Yes.
Tell us what those levels are.
They determine it by 0, 1, 2, and 3. 0 being no rigor, 3 being full rigor.
What did you put in your report for the state medical examiner?
3.
All right, did the child have blankets covering it?
Yes.
Did you touch them?
Yes.
And what did they feel like?
Wet.
Was there anything else unusual that you saw around the child?
I noticed flies and gnats.
Okay, so we expect to be live in the Cheyanne Harris case any moment, keeping a careful eye on that courtroom feed. But in the meantime, we're talking about what we saw in the Zachary Keene trial. Roger, one of the things about this case that maybe makes it so different and so disturbing is that when we talk about victims, you don't get a victim who is as helpless and as innocent and somebody who can't defend themselves like Sterling Keene. And that's, I think, for me, what stands out more than anything. Is that what you feel as well?
Absolutely. I mean, every child comes into this earth with parents, and hopefully loving, caring parents that put that child first and above them. And in that case, we don't see that. We see a guy who was hanging out with his friends, smoking meth in the apartment. That friend didn't even know that he had a child that was in the other room, had spoken about his other daughter, who was a few years older. But it just leads you to a conclusion that maybe these parents didn't want this particular child. And then when you hear that medical testimony about flies and gnats and went rigor on a scale of 4, scored a 3, it leads you to believe that that testimony of feeding that child is not accurate, that child may have been lying in that swing dead even longer than what we heard testimony of.
It's hard to imagine if that's the actual case, and we'll have to see what Cheyanne Harris's defense team will argue about that. Let's take a break. When we come back, we have more to discuss. Stay tuned. This is just one of many witnesses who you can assume is trying to keep their emotion in while describing what they saw, what they heard, just different than anything they've ever experienced before. Back here with Roger Foley. Roger, I want to talk to you about the defense here for Cheyanne Harris. And my question is, do you think, now that Zachary Keene was found guilty, that she can turn around and say, hey, listen, it's all his fault. He was found guilty. You know, this wasn't my fault. It was all him.
No, I don't think so. She was the stay-at-home mom. She had primary responsibility of the child while he was working. I believe it's already been established that he had a job. He was a truck driver, went back and forth on a daily basis. So I don't think that that's the defense. I mean, they could do it, of course, but I don't think that that would be the best decision to do it that way.
And the idea of PTSD or postpartum depression, we heard a little bit of it in Zachary Keene's trial, speaking about Cheyanne Harris. Have you seen it ever been an effective defense? Because we believe, look, this happened. This is a common issue with new mothers, and especially given her age. You had mentioned this before, but I'm curious, how does that actually play as a legitimate defense?
I think it actually can play as a legitimate defense. It's we talked about the fact that there's, I think you said 4 female jurors. They're aware of postpartum depression. Mix that postpartum depression in with someone who's got an addiction to meth, and you got a really bad combination there with the likelihood of death of a child.
But just to interrupt, I'm sorry. The idea that she took that meth voluntarily changes something, doesn't it?
Correct, because it's not an involuntary intoxication defense, which does have some merit, but a voluntary intoxication. She chose to take those drugs, and that's part of what is going to come out in the jury instructions of what the elements that they have to prove and what she did as a mother, as a caretaker, to help this child. And it doesn't appear that she did much. So yeah. I think that postpartum depression, I think that intoxication argument, they're going to lean on that heavily, and they're going to have to put together that foundation so the jury understands it.
Yeah, that's a good point. Okay, listen, let's take a break. When we come back, we're going to talk more about this trial. And again, we do expect to be live now at 11 a.m. Eastern Standard Time. We'll be right back. Welcome back, everybody. So we are previewing the Cheyanne Harris case, which we will be live in today. We now expect to be live with opening statements at 11 a.m. Eastern Standard Time. But if something should happen in the courtroom beforehand, we'll let you know. But we are previewing that trial by going back to the Zachary Keene trial. He was found guilty of murder and child endangerment in connection with the death of 4-month-old Sterling. And one of the most memorable moments was when Sheila Schroeder, a child protective worker, took the stand and explained her interactions with Zachary Keene after Sterling died. Take a look.
You met with Mr. Keene, the defendant in this case. Can you kind of describe his demeanor or how he was acting?
What I recall in the interview, his demeanor presented as that he was laughing throughout the contact that I had.
When you say laughing, what do you mean?
That he was laughing in response to our discussion that we were having.
And this was 2 days after the death of his son?
That is correct.
Did you find that unusual?
I did.
Why?
Typically, when I meet with families who have a child that suffered maltreatment, they're not laughing. They're either frustrated, they're angry, or they're upset.
And it was so unusual that you noted it in your report, correct? Harris, okay?
Yes.
Did you ask Mr. Kane to describe what had happened to his son?
Yes, I did.
What did he tell you?
He explained Sterling's death as SIDS.
As SIDS?
Yes.
And do you know what SIDS is?
Sudden infant death syndrome.
Was he able to provide any other explanation for his son Sterling's death?
No, he did not.
Was he able to identify how often they were feeding their child Sterling?
Not specifically, no.
Was the defendant able to identify the last time that he fed or Sterling was fed a bottle?
I don't recall that Mr. Kane identified a specific time that he had fed his child.
Was Mr. Kane able to provide to you any time or any identifying parental care that he had provided to his son Sterling?
I don't recall any specific information from Mr. Kane.
Did you?
Okay, Roger, we can all agree, if this is true, the behavior from Zachary Keene, it was downright suspicious. I'm curious, from Cheyanne Harris's defense team, do they look at that and say, well, based upon what was presented by the prosecution in that case, we have to do something a little differently here?
I think so. I think that, in his case, there was no remorse. There was no discussion in regards to her parenthood, her being a mother. And I think we're going to hear those facts in this case. They're going to talk a lot more about what was going on in Cheyanne's life and her drug addiction than anything having to do with the boyfriend.
Right. Even though it's the same set of facts, we're talking about a different set of circumstances, maybe different arguments. I want to continue on, though, with Sheila Schroeder, this child protective worker, very interesting witness, and then Roger and I are going to discuss that on the other side.
Can you ask the question again?
Yes. Would it make sense to you that someone would be uncomfortable talking about the death of their child?
Yes.
Does it also make sense to you that someone would be nervous talking about that?
Yes.
Especially somebody who works for the state?
Can you repeat the question?
Especially somebody who works for the state.
Can you ask the question in a different way?
Would it make sense to you, especially that someone would be nervous talking about the death of their child to someone who works for the state file?
Yes.
Did you identify yourself as an investigator when you met Mr. Kane?
Yes, I did.
Do you know Mr. Kane's educational background?
No, I do not.
Do you know whether Mr. Kane was aware of the difference between DHS, Department of Criminal Investigation, or law enforcement otherwise?
Based on his comments, yes.
When Mr. King told you that he used methamphetamine, he told you that he used it to stay awake at work, correct?
That is correct. I need you to repeat the question.
When you followed up, I'll try to break it down. You had followed up on the report, the finding that there was methamphetamine in Sterling's inculpable report, correct?
Correct.
And the records indicated to you that there had been a social work referral, right?
Yes, from within the hospital.
Were you able to determine during your investigation whether there had ever actually been a referral made?
A referral made to where? I guess I'm confused by your question.
To a social worker. Was the report that this family would be referred for social work ever followed up on to your knowledge?
Specifically, no.
Okay, so Roger, I got to ask you, the defense tried to really cross-examine this witness, which is difficult to do in this kind of trial. How did they do cross-examining her, in your opinion?
I think they were doing an outstanding job. They were showing that at the hospital, when the child was born, they knew that the woman was, addicted to meth, that it tested positive in the umbilical cord, and that, whether it be Child Protective Services or whatever agency there is in Iowa, didn't follow up. So you combine that with a 20-year-old that doesn't have a lot of experience, who's addicted to drugs, and basically the government, there's an argument that the government didn't step in, because what you alluded to earlier in the show was, hey, how does this happen? Well, yeah, how does it happen? How does the hospital send a reference to the social, to the welfare worker, to children and family, and there's no follow-up, and this child dies 4 months later? Yeah, that's going to go into the defense's argument. They think they did an outstanding job there, and I expect it to continue with her defense.
Right. I mean, didn't work out so well for him. He was found guilty, and we're waiting to be live in the Cheyanne Harris case, keeping an eye on the courtroom feed. We expect opening statements any moment. But I want to ask you one more quick question about that, though. They also seem to be cross-examining her about how can you judge his behavior after his child died? What do you think of that argument?
People react different ways. If you talk to psychologists and mental health experts, people deal with it different. When I listened to it, when I listened to the 911 call, when I saw the body cam, the way they described, he didn't even rush them into the house. Like, hey, get in here. My child's not breathing. There was none of that. It almost seemed like a person who was not bothered, just maybe under the influence, just sort of non-existent mentally. Because if you're calling saying that your child, you just realized that your child's not breathing, you would think that he would have taken him out of the swing. You think that he would be rushing the first responders into the bedroom. And he's like, yeah, the kid's in the other room. It's like, what's wrong with this guy? What's wrong with this scene? And we realize we have two addicts raising a child and not doing a very good job.
And we were playing in that video where they actually had another two-year-old child together. We're going to talk about how that played into this case and how it may play into the Cheyanne Harris trial right after this break. So we will be right back right after this. Stay tuned.